What should you do if you're involved in a self-defense shooting to avoid prison time? I'm in Texas and we love our guns in Texas. The Second Amendment is integral to every citizen in the United States. So this video pertains to anyone who's involved in a self-defense shooting anywhere in this country. These are things that you need to know. Why should you listen to me? Well, I'm a criminal defense attorney. I'm board certified in criminal defense. And before that, I was a prosecutor. I have a wealth of knowledge to the laws that apply to self-defense. And more importantly, I have everyday experience when it comes to individuals who had to use self-defense. I've seen people make mistakes. I'm going to help you avoid those mistakes. And I'll also tell you what I tell my clients to keep them from having charges filed at all, or if charges are filed, to put them in the best position to get what we have gotten on numerous occasions. That is, their case getting dismissed or even thrown out by the grand jury. If you're watching this, you're likely a responsible gun owner, someone who's put a lot of thought into protecting yourself and your family under the right circumstances. But have you thought about what you need to do to avoid prison time or being charged with murder after you use self-defense? What you do in the moments after you use self-defense are critically important. And let me just start with this. It is an oversimplification to say, remain silent, don't give any statements to the police. It's not terrible advice, but I'm going to give you advice that's even better than simply remaining silent. Let's say you're in a scenario where you have to use self-defense. You've used a firearm, you've shot, someone is hurt, potentially dead. Now, the first thing you should do, assuming you have neutralized that threat and you are no longer in danger, is to call 911. Now, that may seem counterintuitive if all your life you've heard, don't give any statements. But let me tell you this, you need to set very specific framework for the police officers who are going to respond, because the police are going to respond. If you don't call 911, someone who heard those gunshots likely will, and at some point the police have to arrive because there's someone who is seriously injured or dead in your vicinity. So call 911. Calling 911 once you know you're safe is the first step to protect yourself. The second step is knowing exactly what to say. When you call 911, this is what you need to say. I was in a situation where I had to use self-defense. This is my address or location. Then you need to identify yourself. You need to say who you are, and more importantly, what you're wearing and where you will be. So when the police arrive at the scene, they know you're not the bad guy. You also need to tell them that you have put down your weapon, that you are not in the vicinity of your weapon. So that's something you should do, and that's something that you need to convey to them very clearly. You have used self-defense, who you are, and how the police can identify you. Those are the things you should say. Now, on that 911 call, and when the police arrive, they will want to ask you a number of questions. And this is the next thing that you need to be aware of. You should not, after a self-defense shooting, give any sort of detailed explanation as to what happened. Police officers are trained to get as much information as they can. They're trained to ask you questions. In fact, if a police officer themselves are involved in a shooting, even surrounded by other police officers, there would be an investigation into that shooting, and that shooting police officer would be asked many questions. It is in their training to ask those questions. You do not have an obligation to answer those questions. Remember the framework I gave you in step 2. When you call the police, the information that you're supposed to provide them is you were the person who had to use self-defense. You are no longer a danger. You have identified yourself. That framework helps the police understand why you've called and that you are not the aggressor. The rest of any statements that are going to be provided can only be provided after you talk to your attorney. And frankly, they're not going to be provided on the same day. You and your attorney are going to talk, you're going to get some rest, and your attorney is going to advise you on what needs to be said. Understand, although you know you've done nothing wrong, you are speaking to the police or being questioned immediately after a very emotionally charged event. That is not the best time for you to give a statement. You can tell them, I intend to fully cooperate with your investigation. I just need to speak to my attorney first. And frankly, I've been through a huge event in my life, and I just need some time to collect my thoughts. I intend on fully cooperating with your investigation. You can leave it at that. Do not give any detailed statements to the police, you can politely decline those questions. Understand they have a job to do. They're going to ask the questions. You do not have an obligation, nor should you give any further statements at that time. So far, we've covered the first 3 things you should do after a self-defense shooting: calling 911, knowing what to say, and knowing what not to say. What should you do between calling the police and the police actually arriving? Document the scene, but do not alter the scene in any manner. So what does that mean? Most of us carry cell phones or have easy access to cell phones these days. It is perfectly acceptable and even advisable to document the scene using your cell phone. You can take pictures, you can take videos. Why? Well, when the police are arriving at the scene, they may be in a hurry. They may unintentionally trample over the scene. They may move things that are very important completely unintentionally. For example, spent cartridges could be on the roadway, driveway, or in your vicinity. Where those land, and frankly, where they're documented to be, are going to be very important for the police to corroborate ultimately what you're telling them. If a police vehicle drives up and a spent cartridge gets caught up in the tread of the police officer's tires, which happens more regularly than you might think, then that is a piece of evidence that could have helped you that is no longer there. You do not want to alter the scene. You don't want to go pick up the other person's weapon, gun, any casings, but you can certainly take pictures and videos to document what you are seeing in case anything is altered or the police just don't see the evidence that you will later need to help corroborate what you're ultimately telling them. While we're talking about documenting the scene, it's important to re-emphasize the fact that you should not alter the scene. That means don't change anything about what you're wearing, about what your surroundings might include, even if they might be potentially embarrassing. Leave it exactly as it is. The other thing that you can document while you're waiting on the police are witnesses. It is not uncommon for there to be witnesses who say, you know what, I really don't want to be involved in this. If you have a way to document who's at the scene, whether that's by getting their names and telephone numbers or just taking a picture of people who might have been in the area, that will be helpful. And that's because a lot of people will naturally want to avoid situations like this where they might have to give statements to the police. In the time that it takes for police to arrive at the scene, witnesses might leave and you might never be able to locate them again. So as you're thinking about documenting the scene, think about, is there anyone here that saw anything that might be able to help me? And if possible, try to get their contact information. Hire an attorney and have that attorney advise you on what you should say and when you should say it. Your attorney will be able to tell you about the specific laws that apply to your jurisdiction. All 50 states have their own self-defense laws. Your attorney is going to know what applies to your situation. Your attorney is also going to be able to document what happened in a way that best protects you. Now, as important as it is to hire an attorney and contact an attorney as soon as possible, understand there are really 2 goals that you have. The first is, if you can avoid going to jail or being arrested at all, that would be a tremendous outcome. However, you need to be prepared for the fact that some police officers are going to go ahead and make an arrest and let a prosecutor, a grand jury, a judge, or a trial jury ultimately decide whether or not you were acting in self-defense. Because self-defense is what we call an affirmative defense. It is one that can be used to say you are not criminally responsible for shooting and hurting or shooting and even killing another person under the right circumstances. As an affirmative defense, it's one that must be raised in court. While detectives and police officers are certainly allowed to look at a situation and make a determination that they don't want to move forward with a case or a charge, the law says an affirmative defense is actually one that must be raised in court. So if the detective or police officer decides to arrest you, be prepared for that ride. And by be prepared for that ride, I mean be prepared to not give any additional statements. Just because they've placed you under arrest does not mean this is going to end in a conviction. It does not mean that your use of self-defense was not appropriate. They are not the ultimate finders of fact when it comes to that. It is critically important for you to understand that in many self-defense cases, the person who was acting in self-defense is actually placed under arrest. They bond out, and then through the work of their attorney, their case is ultimately dismissed, no billed by a grand jury, or otherwise resolved in a favorable manner that did not result in a conviction and did not result in prison time. By talking, even after you get to the jail, or talking to the police as they place you under arrest. You are locking in a narrative that you have not thought all the way through. You're also likely not experienced in the use of self-defense and what happens as you're using self-defense. For example, you may get tunnel vision. It's not uncommon for you in that moment of heightened awareness to perceive something as a larger threat or larger body than it actually is. Your perception about the size of the other person's firearm might be off. Their height might be off. Their distance from you might be off because your adrenaline is pumping. You're in a fight or flight mode and you had to do what it took to protect yourself or a family member or some other person. The moments after you've used self-defense are not the best moments to give a statement, and even 30 minutes or an hour removed when the police have or are in the process of arresting you is still not a good time to give a statement. So even if you're placed under arrest, be prepared for that ride, because what you're ultimately beating is the rap. You're avoiding the conviction. You're avoiding the wrongful conviction after you used self-defense. So why do so many people say don't give any statements at all? Well, that's perhaps the safest thing to do, because that audience might include people who were justified in their use of self-defense and people who were not justified in their use of self-defense. So if you are potentially talking to someone who may have engaged in criminal behavior, the easiest thing to say is don't give any statements at all. Don't talk to the police. The reality is, by giving the police limited information, that is, you were not the aggressor, you had to use self-defense, you've called 911 to report it, and the remainder of the conversation will happen after you've talked to an attorney and frankly after you've gotten some rest, put you on a pathway to avoid an arrest and maximize the chances that you can avoid a conviction. If you're not certain that the threat has been neutralized, meaning the person you shot might still present a danger to yourself or someone else, or that there might be other people out there that could potentially hurt you, the most important thing you need to do is make sure you and those you care for are protected. While I generally would not advise leaving the scene, because flight after a shooting can be used as an indicia of consciousness of guilt, if you are not safe, then you do need to remove yourself from that situation and make sure you and the other folks with you are safe. That would be the exception where it is certainly advisable for you to leave the scene, and once you know you're safe, then place the 911 call. However, if you know you're safe and the threat has been neutralized, I would advise you to stay on scene so that any potential departure is not looked at as you doing something out of the consciousness that you did something wrong. So what could happen after the police arrive at a scene and conduct their investigation? There are three possibilities that may occur after the police conduct their investigation at the scene. The first is, in fact, the most likely category, and perhaps the one that you least likely want to fall in. And that is the police make an arrest decision simply based on the fact that someone has been hurt or injured and you're clearly the shooter. In that scenario, you might be arrested for an aggravated assault or even a murder charge, because the police officers are going to say it's up to a court, a judge, a prosecutor to ultimately determine whether or not you were acting in self-defense. And as I said, that happens with some regularity. Now, the other two possibilities are you are not placed under arrest. That may mean two things. First, that the police have completed their investigation, determined you were acting in self-defense, and they're not interested in pressing charges against you. The alternative is the police have not completed their investigation. They've just done a preliminary investigation. They're going to look into it more. They're going to talk to a detective and ultimately decide if they want to come back and place you under arrest. They have all your identifiers. They know where you live, who you are. They can come back and arrest you if they decide they're going to press charges. Just as much as I told you, the category of being placed under arrest and having to defend yourself in court is the most common. Having the police determine that you were completely justified in the shooting happens on the fewest of occasions. So it is important that if you're in a scenario where you don't know if you're going to be placed under arrest in the future, or you have been placed under arrest, that you talk to your attorney. You've made it to the end of this video, so you now know what to do if you're in a scenario where you have to use self-defense. What can you do now to better protect yourself if you ever have to use self-defense? First and foremost, take a look at the huge number of Second Amendment insurance providers that are out there. Look for insurance providers that will pay the full freight if you have to use self-defense to protect yourself or another person. What do I mean by that? Well, you need to look for providers, insurance providers, that are covering everything that may come up if you have to use self-defense. There are three areas to think about. Civilly, if you are sued; criminally, if you need an attorney to protect you; and finally, the cost to bond out after you're arrested for using self-defense. As you're looking at Second Amendment insurance providers, you need to take a look at what they're covering. Make sure they're covering the full amount of your bond and make sure they're covering the full amount of defending yourself. That means in a pre-trial setting, which is where most cases are resolved, but also through trial. So providers that will pay the attorney's full fee are going to be far more useful than ones that provide some limited protection. I've been hired on numerous occasions by Second Amendment insurance companies, and I've gotten tremendous results, but I only work with those companies that pay full freight. So if they come to me and they say, I'd like for you to cover our insured, represent them in court, but I want you to do it at a fraction of your normal fee, I'm of course going to turn that down. And what that means is you're going to get a bottom of the barrel attorney to try to represent you in court. On the other hand, there are Second Amendment insurance providers that say, tell me what your fee is, we're going to cover it, we're going to take care of our insured. And that's what you want as you're looking for an insurance provider. You also want someone that's not going to skimp on the money they provide to bond you out of jail if you had to use self-defense to protect yourself. Now, the second thing that you can do as a responsible gun owner is share this video with people you care about. We put a lot of thought into, hey, have I taught my wife how to use a firearm? Has she gotten the training she needs to defend herself? We put a lot of thought into talking to people about when are the appropriate times to use self-defense or use deadly force to defend others. We need to put more time into spreading the word about what you do after you use that force. So share this video with your friends and family. Finally, in the comments below, tell us the best or worst advice you've gotten about what to do after you use deadly force to protect yourself or someone else. Thanks for watching. This video was made in response to some of the Second Amendment questions we get on this channel. We focus a lot on criminal defense matters, personal injury, and family law matters in Texas and in federal court. If you have questions about any of those, drop a comment below and we'll be sure to answer them in a future video. If you like this video, be sure to share it with a friend of yours, particularly one who you want to be a responsible gun owner.